Good morning, everybody. We're going to get started in a few minutes. We're going to be talking about wills versus trusts. I'm Debbie Verni. I'm one of the attorneys at the Herzog Law Firm. And we have offices now in Albany, Clifton Park, Saratoga, and Kingston. And we are doing in-person meetings as well as Zoom meetings. And we are also doing phone meetings. So if after the presentation you'd like to schedule an appointment, you can contact our Albany office at 465-7581. Stacy is at extension 126. Almost gave you my extension instead. And she can schedule anytime on our calendars, like I said, to meet via Zoom, via phone call, or in person at one of our 4 offices. Also, I know probably a lot of you have done a lot of these Zooms, but if you have questions during the presentation, you can actually click on the chat and ask the question. If there's something really personal that you don't want everyone else to know about, feel free to reach out to me after the presentation. My email is dverni@herzoglaw.com. That's D as in dog, V as in victory, ERNI @herzoglaw.com. And you can shoot me an email with your question. I'll try to get back to you. And also, you can give us a call at the office if you have a real quick question. If you do ask a question in the chat, I'll try to get to it during the presentation when there's a place where I can stop and look and answer it. And that's really about it. So we're going to be talking about wills versus trusts. And again, if you have any questions, feel free to pop up and ask a question in the chat room. And we'll start now. So basically, when you're looking at estate planning, if you're over 18, you should have an estate plan. A lot of people think, wow, that's really young. Why would I need an estate plan if I'm 18 years old? Well, those of you that have heard me talk, I talk a lot about my son. And when my son went off to college, I made him do a healthcare proxy and a power of attorney and name me as both, because if something happened while he was away at college, I wanted to be able to make healthcare decisions for him and also to be able to make financial decisions for him. If checks came in and needed me to sign them or something like that. It worked out perfectly. He's graduated from college and kind of moved on to bigger and better things, but I had that security of knowing that everything was in place. Also, a lot of people don't plan for disability. I had a couple that came in the other day that said as soon as their son turned 18, they were going to make sure that he did documents because they had a friend whose son was like 23 years old and had a brain aneurysm. And he was in the hospital. And because the parents weren't the power of attorney and they weren't the healthcare proxy, the hospital wouldn't let them make decisions for him. They couldn't get any access to his money at the bank, right? Because they weren't the power of attorney. And so they were going to have to petition for guardianship in order to be able to take care of their son. It seems kind of crazy, right? Young people, nothing's supposed to go wrong with them, but it does. So we need to make sure that even if we have kids or grandkids that are only 18, that we have some documents for them so that they're prepared. And those of us that are over 18 also need documents. When I was talking about guardianship, that's if you became incapacitated and didn't have a power of attorney, we'd have to do a guardianship proceeding, which is not something that you really want to do. Also, whenever you're doing your estate plan, it can start out really simple. I always say there's really no such thing as a simple will, but you can have simple documents, your basic healthcare proxy, power of attorney, and will. And then whenever you get older, you get more assets, maybe you need a trust, maybe you need to plan for other things that are going on in your life. So getting a basic estate plan in place is really important. So what do you need? You got your basic estate planning documents, right? You got your power of attorney. A power of attorney is a document, I think it's the most important document. Power of attorney allows a person basically to step into your shoes. Anything that you can do, they can do, right? Open accounts, close accounts, change names on accounts, change beneficiaries on accounts. It's a very, very important document. It's a very, very powerful document. So you need to make sure that the person that you appoint is someone that is going to make these decisions for you, right? Someone that has some financial responsibility. Healthcare proxy, this is the person that's going to make your healthcare decisions for you if you can't make them for yourself. If you're laying in your bed, eating your Jell-O and you're talking to everybody and you can make decisions for yourself, they're going to look to you to make your decisions. But if you're not, say you fell off the roof and broke your leg and you're in a coma, they're going to ask your person, can we set their leg, right? Our documents are healthcare proxies at the top and living wills at the bottom. A living will is the document that says, hey, if the doctor comes out and says, I'm not coming back, give me good drugs and let me go. I don't want to be on a feeding tube. I don't want to be on a ventilator. That's the generic language that's in a living will. And then there's the will. And we're going to go through some of the slides and go into more depth about different kinds of wills and different aspects of that, and then into trusts. So power of attorney, right? Just like I said, power of attorney is the person you appoint an agent to manage your financial and legal affairs if you become incapacitated. If there's no power of attorney and you become incapacitated, then you have to petition the court to have a guardian appointed. Definitely not something you want to do. It's a very, very invasive procedure and it's very expensive, right? Not only do you have to appoint an attorney for the person that's petitioning for guardianship, the court has to appoint a person to protect the rights of the person you're petitioning for the guardianship for. So again, lots of different things. You need to make sure that you have your documents all together. Healthcare proxy. As I said earlier, the healthcare proxy allows the person to make healthcare decisions for you, and the living will is end-of-life decisions. Okay, so your will. So your last will and testament, it's the foundation of any good estate plan. People are like, if I have a will, do I need a trust? If I have a trust, do I need a will? I always say that it's like belt and suspenders, right? Do you really need a belt and suspenders to hold up your pants? No, but if one gives way, it's really nice to have the other one there to support it. We're going to go into that in a little bit more depth. So wills. So 55% of Americans don't have one, okay? So they don't have a will. Why don't they have a will? Well, they just haven't gotten around to it. Or they are afraid that if they do a will, that they're going to die. Well, you're going to die anyway, so you may as well have a will and being able to direct who's going to be in charge and who's going to get your assets, right? Because without a will, the state of New York, the lovely state of New York, if you live in New York, will decide where your money is going to go. Generally, it goes to your next of kin, which we're going to talk to a little bit later. But you want to make sure that the person that you've appointed is the person that's going to distribute your money. And you want to make sure that the people that you want to get your money, that you've listed them as beneficiaries. So segues right into this slide, right? So beneficiary. A beneficiary is a person that receives your money after death. So if you have a will and you leave $100,000 to your nephew, right? And then you pass away, and you don't have $100,000 or everything's joint or has beneficiaries, your nephew's not getting $100,000. So we need to do our planning appropriately so that if we're naming beneficiaries in our will and we want them to get our assets, that we've planned accordingly as far as naming beneficiaries and or not naming beneficiaries so that it would be payable to the estate. So your executor is the person that steps up after you pass away, and they're in charge, right? They're the one that's going to be in charge of collecting your assets and paying them out to the beneficiaries. Can the executor and the beneficiary be the same person? Yes, they can. A lot of times that happens. But if they're not, just remember that the person who's your executor has a fiduciary duty to the beneficiary. So if you're ever named an executor in someone's will, and it's kind of funny because I've had people ask me, so who do I name as my executor? And I always say someone you don't like, because it's not a fun job. And, the beneficiaries, I want my money, and you're trying to do the best job that you can. So make sure that when you're naming an executor, that you name someone that can step up, take responsibility, collect up all the money and make the distributions, right? And then you have the probate process, right? So the probate process is the process that your will would have to go through if you have assets individually in your name. So what that means is if you pass away and you have assets that are individually in your name that don't have a beneficiary, that are not joint, we would have to probate your will, meaning we would have to file it with the court and we would have to have all the supporting documentation before the executor could be appointed, before they could collect your assets, before they could make distributions. It doesn't sound like a huge deal, but it can be a huge deal if you don't really have a nuclear family, which we're kind of going to go to in a next slide. So when someone wants to sign a will or someone wants to prepare a will, I get emails from people. Can I do it on LegalZoom? Can I do this? Can I do that? Yeah, you can do your own will if you want to. Will it be valid? I don't know. I always tell people you get what you pay for. And if you're doing your documents on LegalZoom, they aren't generally specific to a specific state. They're generic documents. And I wouldn't do my will on LegalZoom, but you can. But you have to realize that the person that's executing the will has to have capacity to sign, right? So they can't just sign a will if they don't know who they are and what they have. A power of attorney cannot sign a will for a person. A power of attorney cannot sign a healthcare proxy for a person. So even though the power of attorney has a lot of power, they can't do those kind of documents for a person. So better that you get your documents done while you have capacity, while you know where you want things to go. Also, a valid will has to have two disinterested witnesses. What does that mean? That means that if you name Sally in your will, right, and then Sally's one of the witnesses, guess what Sally's getting? She's getting nothing, right? So you need to make sure that you have two disinterested witnesses. The people that are taking in the will cannot be the witnesses to the will. And if you don't learn anything at all from this presentation, and hopefully you'll learn quite a bit, don't make any handwritten changes to a will. If you have a copy of your will, hey, go ahead, mark it up, do whatever you're going to do. But if you're trying to look at an original document, if you have your original document, do not mark on it. I can't tell you how many times I've had people come in for me to review their documents, and I look at their will and I'm like, what's this? Oh, well, George got married and Sally got married and they moved and I had to change their addresses on my will. Or, yeah, I don't want them to get anything anymore, so I just marked them out, but I initialed it. Well, you voided the entire will, right? If you mark on the original document, you void the entire will. So don't mark on your original document unless you want to void your will, right? If you want to get rid of your will, you don't want it to be valid anymore, write on it. So do not write on an original document. Okay, so what I was talking about, intestacy law, right? So if you die without a will, it's decided by the state of New York. So if you die without a will and they look to see if you have a spouse, right? They look to see if you have a spouse. They look to see if you have kids. If you have a spouse and no kids, all goes to the spouse. If you have kids and no spouse, all goes to the kids. If you have a spouse and kids, the spouse gets the first $50,000 and half of the remaining assets. Well, that's probably not what you wanted to happen. And you're thinking, well, that doesn't make any sense to me. I had a situation where we didn't do the estate planning, but it was a husband and a wife. And he had a business that was one that you could get sued for, right? So they put the house in the wife's name. Everything's fine and great. And then she died. And so they had to probate her. Well, she didn't have a will. So they had to do an administration proceeding. And an administration proceeding says that $50,000 goes to the spouse plus half of the remainder. Well, they had two kids. And the son was like, hey, no problem, Dad. This is your house. I'm going to deed it over to you. The daughter, not so much. The daughter's like, nope, it's part mine. I want my money. And the son and the dad are like, it's Dad's house. Yeah, I don't care. I want my money. So she actually fought her father and brother in court. And what they did was when they ended up selling the house, they gave her some money from the house. So, you know what they say, you can pick your friends, but you can't pick your relatives. So best thing to do, no questions asked. You really do need to have a will so that you make sure that assets go where you want them to go. Another problem I see is whenever someone young passes away and they don't have a will and they don't have a spouse and they don't have children, it ends up going to their elderly parents, and maybe their elderly parents are in a nursing home or they're on Medicaid or they're on financial assistance. Well, that money that they inherit is going to throw them off their benefits, right? Going to throw them off Medicaid. That money's going to go to the nursing home. Not what you want to happen. So you definitely need to put a plan together as to how you want your assets to go, right? Where you want them to go and who you want to be in charge. So quickly, goes to spouse, goes to kids, no spouse, no kids, goes to parents, no parents, goes to brothers and sisters, nieces and nephews, goes all the way down to cousins, first cousins once removed. If they can't find one of those, guess where it goes? You guessed it, the state of New York. So definitely, you need to get a plan together. So probate and non-probate property. Okay, we just talked about probating the will. The only reason we probate the will is if the person has assets individually in their name. So if we have someone that has everything that's joint, right? Or it has a beneficiary. So you have your checking, your savings, they're joint, or say you're a single person, you can go to the bank and make the account a TOD account. That's a transfer on death account. So that if something happens to you, that money would go to whomever you name as the beneficiary, right? Because we really want to avoid probate if we possibly can, because it's kind of a mess if you have to go through probate, even if you have a nuclear family. So if everything's joint or has a beneficiary, right? And when you're thinking about beneficiaries, I'm thinking about IRAs, 401ks, 403bs, I'm thinking of life insurance. You need to check your beneficiary designations, and you need to make sure that you have contingent beneficiaries, right? So husband and wife have each other, and then they have the kids, right? Works out perfectly. Something happens to the parents together, then it's going to go to the kids, right? No harm, no foul. So think about that. You need to check your beneficiaries. If you have a situation where someone that was a beneficiary has passed away, you need to update your beneficiaries. If you've gone through a divorce, you need to update your beneficiaries. So you should really look at your stuff to make sure that everything is in order. I know it's kind of a tough job, but you've got some time. Just sit there and make a list of the assets that you have. Follow up with your insurance guy and your financial person and make sure that everything, again, has beneficiaries. It has contingent beneficiaries. Go to the bank, put beneficiaries on your bank accounts. The only thing you can't put a beneficiary on is real estate, which we'll talk about in a little bit as how we're going to transfer real estate without having to go through probate. Okay? So, what is a trust? I wish I had $1 for every time someone asked me that. So, a trust is basically a contract between you and the trustee to hold your assets. So, if it's a revocable trust, you're your own trustee. If it's an irrevocable trust, then someone else is your trustee. So, it's more of a contract whenever you have an irrevocable trust, right? Because you're naming someone other than you as the trustee. If it's a revocable trust and you're your own trustee, I guess you have a contract with yourself. There's different types of trusts. There's testamentary trusts. Those are trusts that are set up underneath a trust or a will. These are trusts that don't exist until you pass away. So, for instance, husband and wife have a will, they leave everything to each other, and then they leave it to the kids, right? Well, that works out okay. But what if the kids are minors, right? What if those kids are babies? And again, you should really, if you have small children, you should really put a plan together, because who would you want to be the guardian of your children, right? Who would you want to be the trustee of your children? So let's just say husband and wife, and then you leave it to the kids and they're young. So what we want to do is we want to say, okay, we leave it to each other and then it goes to the kids. And if the kids are under 25, then it would go into trust for the kids. And then we have to name who the trustee would be, right? Who's going to watch their money. And we also want to put a guardian in there that's going to be in charge of those kids, right? And we don't necessarily want the guardian and the trustee to be the same person. So we have checks and balances. So again, if husband and wife leave it to each other and then they leave it to the kids, and husband and wife pass away and the kids are above 25, then that trust is never going to exist, right? Because that trust was a testamentary trust that was set up for when they passed away. And the circumstance is that the kids are over 25, so there's no trust, right? So it may never exist. An inter vivos trust or a living trust is a trust that you set up while you're alive. So that could be a revocable trust. It could be an irrevocable trust. It could be a special needs trust. There's different types of trusts, but if it's a trust you set up while you're living, it's an inter vivos or a living trust. So all these big words, right? Oh, by the way, after this presentation, they will send out copies of the slides. So you will get copies of the slides. And if you have any questions, you can always touch base with us and ask questions. So depending on what your goals are, will depend on what type of trust you want. And then there's that word privacy. And you're like, why would that be an important term to have on this slide? A trust is private. So what that means is if we have to probate your will, which we talked about earlier, meaning we have to file all that stuff with the court, it becomes public record. So those of you that are familiar, And I always use Mary Lou Whitney as an example because it's easier than using big stars because, it's more home, right? So Mary Lou Whitney, everybody knows that she was very philanthropic and that she lived in Saratoga and she had a lot to do with the Saratoga racetrack. So when she died about a year and a half ago, you saw all the stuff in the paper about how she left different amounts to different people and she didn't treat all of her kids the same way. If she had had a trust, right, that information would have never become public and no one would have known. So, and then they mentioned in the paper that she had property in Florida and she had property in Kentucky. So, not only did they have to probate her will in New York, they would have had to probate her will in Florida and then again in Kentucky. So, a lot of it cost, a lot of attorney fees. If she'd had a trust and she had those assets in the trust when she passed away, the trustee just could have distributed the assets. There would be no filings with the court, there would be no public record, and they could have distributed all the different properties without anyone knowing anything, right? So there's lots of things, privacy is one of those things. If you have someone that's passed away in your neighborhood, friend, relative, whatever, and you think, wow, I wonder where their money went. Well, if their will was probated, you can find out from the surrogate's court. So I don't think the courts are open right now, but once they reopen, you just go into the surrogate's court and you can plug it into the computer and see what happened to their money and where it went. So if you don't want that to happen to you, you should probably have a trust. So a revocable trust. What I said before was a revocable trust is a trust where you're your own trustee. So when we're thinking about a revocable trust, we're thinking about a box with no lid, right? So a revocable trust is a box. It has no lid. You can put assets in it. The assets that you put in it cannot be retirement assets, right? Your IRAs, your 401ks, your 403bs, those assets have to be held by a human, and trusts are not humans. So therefore, those accounts need to stay outside the trust. But in a revocable trust, you can put stocks, bonds, CDs, all kinds of other assets you can put in it. You put a house in it. And because it's a box with no lid and you're the trustee, you can move stuff in, move stuff out, do whatever you want, right? You're in charge. So it's just a holding place for assets. A lot of people do revocable trusts if they have property in two states, right? If I have a house in New York and I have a house in Florida, and I want to make sure that when I pass away, they don't have to probate my will in New York and they don't have to probate my will in Florida. I'm going to put both of those properties in my revocable trust. And then when I pass away, the backup trustee is going to step up. He's going to say, here's your Florida house, here's your New York house, boom, we're done, right? No court, no nothing. Makes everything a lot easier. Again, the trustee is you. You're the person in charge. The beneficiary is the person that's going to get your assets when you pass away. Sounds like a good deal, right? I think I would want to be the beneficiary. So, revocable living trust, like I said before, you manage it. You're your own trustee. If you become incapacitated or you pass away, the next trustee steps up. That's the successor trustee that you appoint. Upon your death, the trust avoids probate. And again, whenever you pass away is when the successor trustee steps up. This is a person you've named. It can be the same person that you've named as executor. It could be the same person that you've named as executor and power of attorney. So this person can wear many hats, but again, they're not going to step up as trustee. You're still in charge. You've still got your box of assets, so you can do whatever you want to with until you pass away or you become incapacitated. So an irrevocable trust is generally used to protect assets, right? It also avoids probate. And a lot of people will do irrevocable trusts so that if something happens and they have to go into a nursing home, that their assets are protected, that they could go into a nursing home and Medicaid would pay for their care if those assets have been in the trust for 5 years. So this is not the presentation where we talk about Medicaid a lot, but just know that right now there's a 5-year look back for Medicaid, meaning if I had to go into a nursing home today and I was looking for Medicaid to pay for my care, either for nursing home or also there's community Medicaid, which I'm pretty sure that one of the presentations is on aging in place. And you can check on our website. Aging in Place is the presentation where we talk a lot about Medicaid and how to qualify for community care, like community Medicaid and or chronic care Medicaid. So if you don't have a chance to see it live, you can also go to our website at www.herzoglaw.com, and you can watch a lot of them because they've all been pre-taped. So I digress, sorry. So we want to set up our irrevocable trust well in advance of having to need any kind of care so that those assets are protected. So there's a 5-year look back for chronic care Medicaid, meaning nursing home Medicaid. Right now, there's no look back for community Medicaid, which is care at home. But the last I heard, they were going to implement it as of July 1st. So that's something you need to think about. If you have someone that you're going to try to get some care at home with, you really need to look into starting to preserve your assets to make sure that they're protected. So an irrevocable trust is a little bit different from a revocable trust. An irrevocable trust, think of it as a box with a lid. Okay, so the revocable trust was a box with no lid, right? You were your own trustee. You could reach in, you could pull stuff in, you could put stuff out, you could do whatever you wanted. An irrevocable trust has a lid. And the reason it has a lid is because you have to name someone other than yourself as trustee. And the reason you do that is with a revocable trust, if you can write yourself a check, right? You can write the nursing home a check. With an irrevocable trust, you can't write checks, right? You have a trustee that does that. If you put stock in there, you can still buy, sell, trade stock. You just can't write yourself a check. You can put your house in there and you can live in it as long as you want to. You can sell it if you want to. But once those assets have been in there for 5 years, if something happened to you and you needed care, those assets are not available to pay for your care. You still get the income. So if you put stocks or bonds in there, you still get the interest dividends. When you put your house in there, you still get your STAR exemption, your veterans exemption, and you still get your capital gains exclusion whenever you sell the house. So it sounds like a win-win, right? And then whenever you pass away, the assets will go to your beneficiaries. The trustee would just call the realtor, hey, put the house on the market, sell the house and distribute the money, or transfer the house to whomever the beneficiary is. So just remember, a revocable trust, you're your own trustee. You can do whatever you want to do. An irrevocable trust is a box that has a lid, right? And so the trustee is the one that's going to be making the checks out. And the thing about an irrevocable trust in the state of New York is you can revoke an irrevocable trust. So sounds kind of wild, right? But in New York, let's just say you put your house in the trust and then 10 years down the road, you sell your house. So now you have this pot of cash that's in your trust. And now you decide you want to travel, or you decide to move into a senior living that's a little bit over your budget. You can do what's called a partial revocation. It's basically a piece of paper that says, I hereby revoke $20,000 out of my trust. You have to sign it. The beneficiaries have to sign it, and the trustee has to sign it. But you reserve the right to change the beneficiaries and trustees. So if they tell you no, or they won't sign the paperwork, you just fire them and put somebody in that will. So it sounds kind of silly, sounds kind of complex, but Harry Miller, one of the attorneys in the firm, he had a client who, this is all before COVID, by the way, had a client who found out that her sister was dying in Italy. And she says to her kids, I want to go to Italy. I want to see my family. I want to be able to stay there for a while. So she says, I need to take $20,000 out of the trust. So we prepared the partial revocation, and it went out to the 3 daughters. We got it back from 2 daughters. The third daughter, which we refer to as the evil daughter, didn't send it back. So we called her and said, did you get the documentation for your signature? And she said, yeah. And we said, are you going to sign it and send it back? And she said, well, mom's old. She's going to die. And by me signing this is taking money out of my own pocket. To which we said, hey, if you look at Article 10 of the trust, mom can remove you as beneficiary anytime she wants to. So I can amend the trust, take you out. She can take her money and let's see if she puts you back in. Next day, Federal Express, we get the signed paper. So even though it's an irrevocable trust and you've chosen somebody else to be your trustee, you're still in control, right? It's a win-win. So when I was talking earlier about Medicaid, again, after the assets have been in there for 5 years, if you had to go into a nursing home, those assets are not available to pay for your care, But if you're not going into a nursing home, again, it avoids probate, and you are allowed to do partial revocations and takes parts of the principal out of the trust. But again, you need everyone to sign off. And remember, the reason an irrevocable trust protects your assets is because there's a lid on the box. And you can't write yourself a check, so you can't write the nursing home check, right? Pretty simple. So these are kind of the highlights. So why am I going to do a trust versus a will? So with a trust, there's no probate. With a will, there's probates, costs, and delays. And you're thinking, well, it's not going to be a big deal for me to probate my will. Well, right now, it's probably not. But a year ago, when the world shut down, right, because of COVID, the courts and everybody were not open and people were still dying. And what would happen, right? So luckily enough, it was spring and it was warm. But what happens, right? What happens if someone passes away and there's a house and it's the middle of the winter and the house is individually in their name and the bank accounts are individually in their name. And now all of a sudden you're trying to figure out who's going to pay the funeral bill, right? Who's going to pay for the upkeep on the house? Who's going to pay the utilities? Who's going to make sure that everything is shoveled, making sure people don't break into the house, right? With no money, right? They can't get appointed. So probate does take a while. And you need to kind of plan for that, because if there's something that's high maintenance, or if you have a business, God forbid you have a business and we have to probate your will, who's going to sign the paychecks? Who's going to keep the business going while we try to get you appointed as executor, right? A trust manages assets during your life. A will doesn't come in effect till you're deceased, right? So the will has no control. Your beneficiaries aren't entitled to anything. Your executor is not appointed until after you pass away. So the trust kind of is obviously while you're living, inter vivos. The will is after death. So what about your financial affairs becoming private? Well, I would want mine to be private. I mean, it's not really that big a deal, but there's privacy issues, right? Maybe there's a situation in your family that you don't want people to know how much you had, or you don't want them to know where stuff went. If they have to probate your will, they're going to know, right? It all becomes public record. So privacy is a good thing. And it's harder to contest a trust than it is a will. Classic example. So let's just say I marry a guy that has 2 kids from a prior marriage, right? And then he and I have a child together, and then he dies, and he has a will that leaves everything to me, of course. And what we have to do is we have to notify all of the intestate distributees, right? So those would be our son and the 2 kids from his prior marriage. And what we do is we have to sign them a waiver. This is if we have to probate your will. We have to send them a waiver that says, hey, do you have any problems? We're going to probate this will, and she's going to become executor. Well, this gives them an opportunity. If they don't sign the waiver, then we have to send out a citation, and then that gives them a day to appear in court. So that gives them an opportunity to go into court and say, there's no way, she was an evil stepmother. She was a wicked, awful person. She was standing on his oxygen tube and made him sign the will and leave everything to her, right? So airing your dirty laundry in court. Whereas if my husband had everything in trust and it went to me, it would just be mine, right? There'd be no court, there'd be nothing else. Remains private. The kids can't come in and contest it and say how awful I am. Not that they would, of course, but that's just an example. So you're kind of opening yourself up if your will has to be probated in court, or if you don't have a will. And then they would have to notify the exact same people. So you definitely don't want to put yourself in that kind of position. So thinking about it, what's right for your family? A will versus a trust. Whenever we do a estate planning questionnaire, so if you called up and you said, I want to make an appointment and I want to meet with one of the attorneys, what we do is we send you out this questionnaire. It's kind of like whenever you go to the doctors and you have to fill out a questionnaire with the doctor. This very similar. It basically asks questions, and everyone is like, wow, I am so glad that I filled this out because I forgot about all this stuff, right? I forgot about this really old life insurance policy, and I forgot who my beneficiaries were. It really helps you put things in order. Then we meet with you with that, and we determine what assets you have, and if they have beneficiaries, or if we're going to set up a trust. And then we set up beneficiaries, right? Who are you going to leave money to? Are you going to leave money to your kids? You're going to leave it to pets? We do pet trusts. Are your kids minors? Do you have someone with special needs? Do we need to do some special needs planning? Do you have a child that has an addiction problem? Some of the favorite trusts that we have are trusts that say that, you know, if a child has a substance abuse problem, that they have to get drug tested before they get a distribution. One of the fun ones that we had actually years and years ago, it was a trust that said that the child didn't get a distribution unless they had a W-2. And then they got a distribution equal to the amount of their W-2, right? So they didn't work, they didn't get money from the trust. They didn't want their child to become a trust fund baby. So those are all the things that people think about whenever they come in and we talk to them, well, what about this one? What if this person passes away? What if that person passes away? And they're like, but I don't want to have to think about that. Unfortunately, that's our job, to make you think and to make you plan. And we also want to figure out who you're going to have as your fiduciaries. Whenever you're choosing, you know, your executor, your healthcare proxy, your power of attorney, don't go through the list of your 7 children and just say, okay, this one's number 1, so we're going to make them executor. This one's number 2, so we're going to make them trustee. You really need to think it out and make sure that the person number 1 that you appoint wants to be appointed, and number 2, that they can actually do the job. So when would we think about doing a trust? If we have real estate, you have real estate in more than one state, right? But even if you just have real estate, husband and wife, usually there's no probate whenever the first one passes. Second one passes, we end up in probate because, again, you can't put a beneficiary on a deed. Better to have a trust. Business assets, if you have a business, if you have an LLC, those LLC shares can be assigned to a trust, and therefore there wouldn't be any probate, and you'd be able to keep running your business, right? Makes it a lot easier. You want to avoid probate. You want to protect yourself from Medicaid and from lawsuits, family conflict, and again, privacy. So there's a lot of reasons why you would want to consider a trust over a will. And this is the last slide. So you're free to give us a call or email us and set up a free consult. As I said earlier, we'll meet via phone, we'll meet via Zoom, we'll also meet in person in one of our 4 offices. We do make house calls if there's people that can't make it out. We have a radio show every Saturday morning from 8 to 9 a.m. on Magic 590. It's a call-in show. So there's generally 2 attorneys that are on, and we have calls, people ask questions, or you can just sit and listen. The webinars, this one and a bunch of others, are all pre-recorded on our website. So if you want to watch some of the webinars, and I have had several people tell me that they binge watch seminars, which is fine. It's kind of like Netflix, right? You turn it on and you can pause it and go get popcorn and drinks or whatever you want to do. But if you have questions, most of them have been recorded and they're on our website at www.herzoglaw.com. And again, if you have some questions, you can email me at dverni@herzoglaw.com or give us a call at the office. And thank you very much for attending this today. There's another webinar at 2 this afternoon, and we have them every Wednesday at 10 and 2, other than the week that we have a week of webinars, which is week after next. So if you're interested in attending more webinars, feel free to go to our website at www.herzoglaw.com. And thank you for joining us today.